Hello friends, I welcome you all to this 23rd session on Law of Evidence. In this, we will be discussing from section 34 to section 39 regarding relevancy of certain statements. So let's have a brief overview as to what we are going to study in this section. These sections are important from the point of view of preliminary examination, as sometimes they may give the statement and ask as to these statements are relevant under which section of Indian Evidence Act. For example, many a times they have asked that the statements contained in maps are relevant under section 37, 38, 39, 36. So there we will have to just try to interlink the number of sections with the content of the section. And moreover, from the practice point of view as well as from the point of view of giving judgment, these are important as it shows relevancy of certain statements. So let's see section 34. So section 34 deals with relevancy of certain entries made in books of accounts. We will see that to what extent those entries are relevant and for what purpose those entries are relevant. Then the section 35, they have discussed entries in public records. Now, public record, for example, the daily diary which is kept in police station, or the birth and death register which is kept in the municipal offices, how relevant they are or how they are made relevant, we will see under section 35. Under section 36, as I told you in the question also, that many a times, this is very important section which they have asked many a times, that statements in maps, charts and plans, when they are relevant, as to what are certain conditions that should be fulfilled so that they can be relevant. Then section 37, it makes relevant certain facts which are contained in acts, that is the legislative acts passed by the legislature or certain official notification, and they should be of public nature. That is, the facts which are made relevant are those facts which are not private nature but of public nature. Then the section 38, statements as to law contained in law books. These are regarding the law which is foreign law. So how do we infer or how do we come to an opinion as to foreign law? That is contained in section 38. Then section 39, they deals with how much of a statement is relevant. For example, suppose there is a conversation that is uh, going in number of pages, or there is a record that is very numerous volume. There are numerous volumes of it, 8 volume, 10 volumes. Then how much? It's if the parties are allowed to prove all the 8 volumes or 10 volumes of a book, then it will become very difficult for court to give the judgment within limited time. Now, so section 38 makes very specific as to how much of the statement would be relevant in those cases. So here we are going to discuss from section 34 to section 39, and these are the brief overview as to what all we are going to discuss. So let's begin. So first of all, and I have tried to give a picture also. Mind you, these pictures are just so that you can correlate them and remember them better. And they are not anything which is very which are contained in the act or which are contained in the law. So section 34 or section 34 to section 38 are normally dealing with statements made under certain special circumstances, as we have discussed while we were discussing the brief overview of the video. So section 34, I will just give a reading to the bare act, Entries in book of account, including those maintained in an electronic form, regularly kept in course of business, are relevant whenever they refer to matter in which the court has to inquire, but such statements are not alone sufficient to charge any person with liability. So section 34, they make relevant entries in the book of accounts. Now, entries in the books of accounts are made relevant under section 34, but with certain conditions. First, these entries must be regular, those which are regularly kept in course of business. So if they are not regularly kept in course of business, then they would not be relevant. Now here I will just refer to Jain Hawala case. Now in Jain Hawala case, what happened is that certain famous personalities, political personalities, where their name were written in a Hawala diary, in a diary which was kept by a person who was accused of Hawala trading. Now, the question was whether the names mentioned in that diaries are admissible or are relevant or not. Now, as no dates on which the payments were supposed to have been made were there in the diary, so that it was not, the prosecution was not able to prove that the diary was regularly kept in course of business, and therefore it was held not admissible. So, first thing, for those entries in books of account to be relevant, the first condition which must be fulfilled is that these entries should be regularly, or these entries should be in account book which is regularly kept in course of business. That is one thing. Another thing is that, which must be remembered and which is very important, is that they alone are not sufficient to charge any person with liability. That is, they are just corroborative piece of evidence, and they need certain corroboration or certain independent evidence also to charge any person with liability. So two things for entries in books of accounts to be made relevant are to be kept in mind. First, those entries should be regularly kept in course of business, like it is done here. It's the dates are mentioned, the amount is mentioned, so it should be regularly kept in course of business. And secondly, that they are just, they alone are not sufficient to charge any person with liability. They are only corroborative evidence. Independent evidence would be required for fully proving or fully charging a person with the liability. Next is section 35. Now what is section 35 is that the entries made in public records. Now, entries which are kept in public record, they have been made relevant under section 35. But as in the section 34, again certain conditions are mentioned here. Now, what are those conditions? First is that those entries must have been made by the public servant. So it should not be like any person, private person would have had made that entry. No, that entry must have been made by the public servant. And second important thing, for those entries to be relevant is that it must be done in discharge of his official duty. That is, he must be a public servant, and he must have made those entries while he is discharging his official duty. So if in a station diary like here, an entry is made by the DD writer or a person who is on, police officer who is on duty, then they will be relevant under section 35 because they are made by public servant and discharge of his official duty. But mind you friends, if the same entry has been made by a police officer who is not on duty, who is off duty, then they would not be relevant under section 35 because it has not been made while he was discharging his official duty. Similarly, a municipal record of a person's date of birth or death is relevant to prove the date of birth or date of death of the person concerned. So where the question is what is the date of birth or date of death of a person, then the record which is kept by municipal authorities, those record would be relevant because those are made by public servant in discharge of his official duty. So that is what is section 35. Now, under section 36, as I told you, this has been asked many a times in preliminary examinations. So, here the relevance, what things have been made relevant are statements made in maps, charts, or plans. So, statements made in maps, plans, or charts. Now, those statements have been made relevant provided that they are meant for public sale, that those maps, plans, or charts are made for public sale, or they are prepared under the authority of state. So, two things must be there, that is, those maps, plans, or charts, either they should be for public sale or they should have been made with the authority of a state, then they have been made relevant under section 36. Now, section 37, it makes relevant certain statements in acts of Parliament of India as well as England. So, certain statements which are made in the government notification or official gazette or any act have been made relevant provided they are of public nature. The gazetted statement are the best evidence of facts stated in the Gazette. So if anything is published in the Gazette of India, then they will be relevant as far as if it is to be proved that they are public statements or they are statements of the government. So anything which is published in any act or which is published in any government notification or in official gazette are relevant to prove any fact of public nature. Now, section 38 deals with that when the court has to form an opinion as to law of any country. So, suppose whether a particular law is there in Tunisia or not, or whether a certain law is there in Poland or not. So when the court has to form an opinion as to law in a foreign country, not in India but as in a foreign country, then what are relevant is the two things have been made relevant under it. What are those? Statement of law of that country contained in book printed or published under the authority of the government of such country. So any book which has been published by the government of that country and which contains the law. So any law book published under the authority of the government of that country, then that book, the thing which is contained in that book, the law which is contained in that book will be relevant if the court has to form opinion as to foreign law. So if whether a particular law is there in Poland or not, then the book which is published by the government of Poland regarding that law will be relevant. Or another thing which have been made relevant is any report of ruling of the country or courts of such country. So anything which the court of Poland has ruled, now that report will also be relevant or that has been made relevant as far as section 38 is concerned. So what section 38 does is that when the court has to form opinion as to law of any country or a foreign law, then two things have been made relevant. One, the law which is contained in the book printed under the authority of that government, or the law which is published in any report of the ruling of the court of such country. So these two have been made relevant under section 38. Now section 39 is a special section which deals with how much of a statement is to be proved. That is, suppose there is a conversation, long statement, conversation, document, book, or series of letters or papers. For example, I have made a picture also. Now, if everything is allowed to be proved, then it will be very difficult, it will be very problematic for court to deal with the case in on timely basis, and it will be totally a futile exercises. It will not be serve any purpose. So what section 39 is says is that only so much of a statement which is necessary for full understanding of the statement in the particular case will be allowed, or court may allow in its discretion, to be proved or to be relevant. So where a long statement, conversation or document or electronic record or book or series of letter or paper is relevant to any proceedings, the court may, in its discretion, require the production of only so much of a statement, conversation, or document as is necessary for full understanding of a statement in the particular case. So, when series of long conversation or series of long document is relevant, then court may in its discretion says that only this much needs to be produced because only this much is sufficient for full and complete understanding of the matter or fact in issue. So that is what is section 39. Let us have a quick recap of as to what all we have done today. We started with section 34, in which it is said that entries in books of account has been made relevant provided they are kept in regular course of business first, and second, they are only corroborative evidence and are not alone sufficient to charge any person with liability. Then the section 35, entries made in public records have been made relevant provided they are made by public servant and they are made in discharge of their official duty. Then the section 36, statements, maps, plans or charts have been made relevant provided they are meant for public sale or they are prepared with the authority of the state. Then under section 37, if the statement is regarding a public nature, fact is regarding that of a public nature, then any statement contained in any act, government notification or official gazette have been made relevant. Then under section 38, when the court has to form opinion as to a foreign law, then statement regarding that law contained in a book published by that country or statement regarding that law in any report of a ruling of the court of that country are relevant. Then the section 39, which deals with how much of a statement is to be proved, then only when a long statement or large document is relevant, then all court may allow only so much to be produced which are necessary for full understanding of the statement in that particular case. So that's all for today. Thank you.